Any mention?
Okay.
Please, Your Lordship.
Yes.
I beg to mention item number 30, Lordship. Item number 30.
1 minute. SG Enterprise.
Yes, Lordship.
1-3.
No, Lordship. 30.
Nasiruddin Purdani.
Yes, Lordship.
On whose behalf?
On my, behalf of Mr. Sheikh, Lordship.
Mr.
Sheikh. As a Sheikh.
Why?
He's on leave, Lordship.
So what is on leave? You're here?
I'm not that competent, Lordship.
Or not competent? Yes.
No objections.
Similar prayer, Lordship. All 31, 32, 31, 32. Connected matter, Lordship.
Lordship, yes. 30.
What about the petitioner and 32?
Have you taken action?
You ready with the matter?
Lordship, actually, we are supposed to. We require some instruction, Your Lordship, from the client, Your Lordship.
Okay, after 2 weeks.
Really obliged, Lordship.
31, 32. 30, 31, 32. Yes.
Please, Your Lordship, I beg to mention item number 36.
Number?
36, Your Lordship. Your Lordship, I pray for 2 weeks more time to obtain my death certificate, Your Lordship.
What's the matter about?
Payment of areas, Your Lordship.
Areas of what?
Graduate scale of pay, Your Lordship. Graduate scale of pay.
Gratuity?
Yes, Your Lordship.
Lordship, he died, the petitioner, I believe.
Yes, Lordship. We're still waiting to obtain the death certificate, Your Lordship.
Oh, he died?
To substitute, yes, Lordship.
In 3 weeks, yes.
Apply, Your
Right,
Lordship.
Your Lordship.
3 weeks as the petitioner said to have since deceased days.
Apply, Your Lordship.
Yes.
Please, Lordship. Lordship, I beg to mention item 28. 28. So we can only have it after 2 weeks.
No objection, Your Lordship.
Why?
Not keeping well, Lordship.
Well enough to come to court, not well enough to argue. Yes.
Obliged, Your
Obliged,
Lordship.
Lordship.
May it please, Your Lordship. Lordship, I beg to mention item as 38, Your Lordship.
Number?
38.
38.
Yes, Your Lordship. If this matter could come after 2 weeks, Your Lordship.
Yes.
No objection.
What's the matter about?
It's pertaining to the refund of the amount paid by the petitioner to the respondent relating to a sales deed, Your Lordship.
Okay, 2 weeks. Yes.
Much obliged, Lordship.
May I please, Your Lordship, I beg to mention item number 39. Item number 39.
Yanamul Haq. On his behalf, Mr. Debnath's behalf.
The matter may come after 2 weeks.
Yes?
After 3 weeks, Your Lordship.
Why 3 weeks?
We need some instructions.
It's regarding distribution of food grains, Your Lordship.
Food grains?
Food grains. That is being distributed, which is why they are not.
Where's the senior?
He's in another courtroom.
2 weeks. Yes.
Item number 40 is connected.
Yeah?
Item number 40, similar prayer.
Where?
Similar prayer for item number 40.
Number 40.
They are connected matters.
Okay, 2 weeks, yes.
Lordship.
May I please, Your Lordship. I beg to mention item 33.
30?
33, Your Lordship.
I'm for the respondent, Lordship. No objection.
1 week or 2 weeks?
2 weeks, Your Lordship.
Now you should start on Monday. Yes.
Obliged, Your Lordship.
Adjourn all the cases.
May I please, Your Lordship. I beg to mention item 37.
30?
37.
Where's the other side? Mr. Suna, your objection?
Keep him over.
1 week
2 weeks, Your Lordship. I'm appearing on behalf of respondent 4 to 70.
on Mr.
4 to 70.
I'm appearing on behalf of respondent 4 to
2
70.
weeks. Yes.
Obliged.
Item number 1.
Lordship, I'm praying for some accommodation for today.
For a day.
For today.
For a day is okay.
I'm praying that this matter may come tomorrow, subject to Lordship convenience.
Tomorrow. This is what this. MS Nyang says that the matter we could do tomorrow. Yes. It's the matter tomorrow.
Item number 2. May it please your Lordship. Lordship, on the last date, I had craved the leave of this Honourable Court to file the condonation application. The condonation application is on board today. There is a delay of 148 days.
Yes.
But this 148 days gets completely covered during the pendency of the appeal. If we count the effective number of days within which the review has been preferred, it is 25 days. So there is
25 days?
Yes.
Yes, Mr. Shulai.
May it please your Lordship. Lordship, in my humble respectful submission, your Lordship, this application is cannot be entertained.
Why?
Lordship, kindly come to page 1, your Lordship.
Page 1.
Lordship, yes. An application filed under section 5, your Lordship. Lordship is Limitation Act is not applicable in the writ proceeding. Under 226, your Lordship, is not applicable. So, in view of the fact that the Limitation Act is not applicable in writ proceeding, your Lordship, so the Limitation Act also will not be applicable in review, your Lordship, because this review application has been filed to review the order passed in a writ proceeding. It cannot, your Lordship.
Yes.
Lordship, in my humble submission, as far as my knowledge goes, the Meghalaya High Court rules does not provide a specific rule. So the
For filing review.
For the number of days, my lord.
For review.
To
It's
my
not there in
knowledge,
High
my
Court
lord.
rules. Let's see what chapter.
No, there is no thing as such, your Lordship, in the High Court.
It is, I'm not very sure, but to my as far as my knowledge goes, it does not provide, my lord. So the applications all throughout which have been filed for condonation of delay before this honourable court have been under section 5.
Is by application of the general spirit of CPC. Yes.
Yes, my lord.
Yes. Yes. Let's see.
Further, my lord, when we file writ
1 second.
appeals, my lord.
Decree for appeal, revision. Flip shot it. Yes. So what to do, Mr. Shulai? Reject the application?
It cannot be entertained, your Lordship. Because if the Limitation Act is not applicable in a writ proceeding, your Lordship, it cannot be applicable, your Lordship, also in the review.
Then, my lord, in writ appeals also, we have always been filing application under section 5. Writ appeal.
Under the Meghalaya High Court rules, your
But
Lordship.
the condonation application part is not there. So a limitation act will not apply to writ appeal also in that case. Then how can applications under section 5?
No, writ appeal applies. It's the times prescribed for writ appeals.
My lord,
In
the number of days is
rules,
prescribed.
yes.
But how does limitation act come there? That is also arising out of a writ proceeding only.
See, Mr. Ashwara is putting a very technical objection.
It is very technical, my lord.
You have to meet it on technical submissions. 1 second, this is our rules of High Court in regard to other procedures here.
High Court rules.
We repeat 30 days for writ appeal. Yes.
Yes, my lord. Writ appeal, it is specifically 30 days.
Yes.
And this honourable court, while exercising jurisdiction under 226, has the power to not consider this Section 5 Limitation Act which has been written. or which has been typed in the petition.
Nomenclature will not make any difference.
Yes, my lord.
Yes.
Nomenclature will
That's
not
what
make a
it should
difference. For condonation of delay, the spirit of CPC applies. That is why it is within 30 days for review, for filing a review.
Where's the thing? 1 second. Review, normal review is here.
So far as due diligence on the part of the petitioner is concerned, that is duly being pursued. Within 30...
What do you want to review? Okay, what do you want to review?
My lord,
On what ground do you want to review?
my lord, the findings in the inquiry report are contrary to the affidavit filed by the state respondents before this honorable
The findings
court.
then?
The findings in the review in the inquiry report is different from the affidavit filed by the state respondents before this honorable court.
Doesn't matter the inquiry. Why you didn't take part in inquiry and come to
My lord,
documents?
we have taken part in the inquiry, but there are certain aspects which have not been taken into consideration.
You're not going to open that inquiry for any education.
My lord,
You still remember that. It is review is what? Review jurisdiction is what? We'll condone a delay, Mr. Shilayat.
on apparent...
Yes.
My lord, may I kindly see para 4 of the petition that she has filed, my lord.
What for review?
Condonation application.
Okay.
Yeah, para 4. A false statement has been made on oath, my lord, before this honorable. Then the petitioner state that the honorable division bench, in his order dated so and so, directed that the period during which appeal was pending shall be excluded, my lord. Shall be. Whereas there is no such word shall be, my lord. They have said, my lord, in para 7 of the appeal. Maybe, my lord.
My lord, it is made clear that the period during which...
My lord. Maybe, my lord, is my lord is...
Where's the order?
My lord, page 38 of the review petition.
Why you written shall then?
My lord, it is an oversight, my lord. It was...
That means you're commanding this court to...
No, my lord. No, my lord. No, my lord. That otherwise... Page 38.
This court, yes?
Page 38, Your Lordship, para 7. Somewhere in the middle, Your Lordship.
Second last line, my lord. Page 38.
Yes.
It is made clear that the period during which the writ appeals...
Make it a period during which the appeals are pending may be excluded for the purpose,
of
commuting the number of days.
In filing the review petition. Lord,
Lordship,
I admit
kindly
that
come,
this is one mistake. Instead of may, it is shall. I have given an explanation as well.
1, 2, 3, 4, 5.
I have given an explanation.
No. Why have you written here that shall be?
Lordship, kindly come from 5 sentence from the bottom, Your Lordship.
I completely admit that.
So you're commanding this court
No, my lord.
to condone a delay on the basis of order of the division bench?
Not on the basis of division bench, my lord. On the basis of the
if you're reading a pleading,
sufficient
that's what it
cause.
says.
On the basis of... my lord, if your lordship kindly sees paragraph 2 and 3, my lord. That the petitioner states that the period of limitation for preferring review against the impugned judgment and order dated is expired on 22/12. That the petitioner states that he preferred a writ appeal against the impugned judgment on 8/12/2023. That was, my lord, only within 13 days, which was registered as WA number 50 of 2023. The said appeal was disposed of upon withdrawal by order dated 8/5/2024 with liberty to prefer a review petition before this honorable court.
Then he did dispose?
My lord, that the petitioner states that the honorable division bench in its order dated 8/5/24 directed that the period during which appeal was pending, this is my mistake, instead of shall, it should have been may. May be excluded from computation of delay. My lord, indeed. As such, effectively, there is no delay in preferring the review petition. That the petitioner states that the delay in filing the review within the statutory period was due to the cause which was beyond the control of the
Why did you withdraw the writ appeal? You could have if you let the writ appeal continue, then you could have entire merits of the judgment passed by this court.
My lord, it is absolutely your lordship's discretion whether to interfere with the judgment or
I'm saying why do you not review jurisdiction very limited?
My lord,
have you brought anything new to consider before this court?
My
or
lord,
something escaped this court does not recorded? What was that?
My lord, today I am on the miss case, but in brief I can state before this honorable court.
Yes, what are the grounds for review?
My lord, the first ground is I'll start with the item number 2 itself.
What is the
my lord, in item number 2.
Yes, my lord. What was left out by this court,
Yes, my lord.
which was not there before?
My lord, in the inquiry report, it is stated that Nazila Begum was appointed as a language teacher in 2017, whereas in the said writ petition and the background of Nazila Begum, why did she come before this honorable court, was that her salary was being deducted, she being an additional teacher. She filed the writ petition in 2017. Now, my lord, the affidavit in opposition in the said writ petition was filed in 2018 by the school managing committee. The appellant, the review petitioner herein...
Okay, forget about Nazila Begum. What is your ground? You are
my
Nurul
lord,
Amin.
I am telling the ground, my lord.
You are never a sanctioned teacher, you are a,
no,
you are
my
a
lord.
fake teacher.
No,
then?
my lord. It's not true.
What is your ground? Don't touch the case
my
of other
lord,
people.
so
they
far
stand
as
on their own.
so far as my
the
appointment
of the other respondents,
my lord,
that will
so
not,
far as
the respondents will not help your case.
my lord, so far as my appointment is concerned,
yes.
my appointment
that have you able
yes,
to you could not
my lord,
inquiry committee.
no, my lord.
Yes.
In WPC number 264 of 2020, I had challenged the appointment of Shabuza Begum. The government, instead of responding to the averments made in the writ petition, has questioned my appointment in that. And to that effect, I have filed a detailed rejoinder which starts right from 2010, my lord. In 2010, this Khetadoa SSA UP school was upgraded as a SSA UP school. It was a lower primary school. I was the founder.
The very reason,
my lord,
the reason this court sent the matter for an inquiry by the Commissioner Secretary of the Education Department is because of the entire thing was, what it came down to is that one person called Nurul Amin is responsible for the entire mess in the school. Yes. And that is true, review petitioner. So again now, when the inquiry was there, you went only once or twice, you never bothered to show your face again because you knew you had no materials. And then you went for appeal now, knowing you're not going to succeed, then you withdraw to file a review.
No, my lord. No, my lord.
What is no?
My lord, in this...
You only, see,
my
review
lord,
jurisdiction is what? Just listen. Show the court that at the time when the matter was here before this bench,
yes, my lord,
there were some materials which have developed later on, which have been found out later on, which are which are relevant and germane to be looked at again. That's review. Or you can't do that.
My lord, the rejoinder file.
What rejoinder?
In WPC
you start from an inquiry. We're not going to a rejoinder.
My lord,
you go from
so
the
far
inquiry.
as the inquiry is concerned, yes, my lord, with regard to the inquiry itself, I have taken grounds in the review petition, and today, since only the miscase is concerned,
we'll condone it. We'll condone it. No problem.
My lord,
yes.
and after
we'll overlook your lapses.
My lord,
next
week the matter may be taken up,
we'll
and I will
satisfy. Today we take up today.
My lord, so far as
review jurisdiction,
my lord,
it is very short.
My lord, miscase was there. So I am not completely prepared with the review today, my lord. That is why I am praying for next week. I will come absolutely, I will try my level best to satisfy this honorable court why the review is maintainable and why the order dated 24/11/23 should be interfered with, my lord. Rest, my lord, it is your lordship's jurisdiction. I have nothing more to do.
What do you mean lordship's jurisdiction?
My lord, your lordship has the power. Whether your lordship finds it a fit case.
See, please remember, if there was something,
my lord,
if there is something rather that is new or escaped the court's attention at the point of time which affects the whole thing, it turns upside down, then the ground for review.
It is, my lord.
Otherwise,
you've
taken part in the inquiry. You have not been able to show even one scrap of paper that you're an illegal appointee.
I will show, my lord.
Have the criminal cases been drawn up against him?
Yes, my lord.
Lordship, yes. Yes, my lord.
They have been have you been?
He is appearing, my lord.
He is appearing for the criminal court.
My lord. Whatever stage it is at, I am not aware about the exact status right now, but he is cooperating. I have already advised him.
Okay, we'll give us some time. See, application, review petition, miscase. What's the miscase? Miscase number?
4, my lord.
4, yes.
4 of 24 in review petition 4 of 24.
This is an application for condonation of the delay and preferring the instant review application against the order dated
24/11/2023.
24/11/2023 passed by this court in WPC number 383/2017. The learned counsel for the petition submits that the delay of 178 days.
148, my lord.
140 was caused in view of the fact that writ appeals had been preferred against the order date 24/11/2023, which was subsequently withdrawn on 8/5/2024, with liberty to prefer review petition before this court. Stop. The submits division bench of this court directed that period shall be excluded.
Maybe, my lord.
Yes, maybe excluded from completion of delay. She prays that the matter be taken up for consideration and the review matter be taken up for consideration. As Mr. Andy Shulai, next paragraph, AG has voiced strong objections. Firstly, on the ground that Limitation Act not applicable and the application is styled as a application of Section 5 Limitation Act 1963, and further objection has been raised by the correspondent, Mr. SD, that there has been a misinterpretation of the order of the division bench dated 8/5/2024, and as much as shall, the word shall, when single was never used and was only may. Stop. Having heard the counsel with the parties, notwithstanding lapses on the part and the deficiencies of the condonation application, interest of justice, the delay is condoned and the petitions be diarized and to be taken up for consideration. Just after 2 weeks, yes.
Apply, Your Lordship.
Item number 3.
You prepare well.
3 and 4 are same, my lord.
No,
The only the WPC number will change.
Apply, Your Lordship.
Item number 5. 2, 3 and 4.
In this matter, the pleadings are complete, my lord. We can.
What pleadings are complete? You're supposed to close it today.
Except for hearing.
No pleadings. Yes. Where Dr. Musika?
Lordship, he's on legs, Lordship.
We can have it next week, my lord, for final disposal.
But the orders remain. You are still protected.
Yes.
Yes. So contempt. What contempt will be there now?
Well, let it be heard together, my lord, next date.
Okay, Mr. Hapa, learned counsel with the petitioner, submits that the matter be listed for hearing instead of being disposed of at this stage. Yes. List accordingly also for hearing.
6.
5 to 7.
5 to 7.
8. Item number 8.
Please, Lordship. They are supposed to file. They have not filed the affidavit. Your Lordship,
We are filing
the
the course of the day, my lord. Course of the day, we are filing it, my lord.
Mr. SD submits the application file course of the just after 2 weeks.
Yes, Lordship.
Item number 9.
Your Lordship, I pray for 2 weeks' time.
For what?
To file a rejoinder.
How many times you sought, Mr. Datta?
I beg one?
How many times you sought time for rejoinder?
I can't recollect now.
You can't recollect?
Yeah.
Listed for hearing. After 2 weeks, in the meantime, rejoinder will be filed by the petitioner.
Obliged.
Yes.
10.
Your Lordship, 2 weeks' time may be granted for filing rejoinder, Your Lordship.
Two and three, no appearance?
No, my lord.
Yes, further 2 weeks' time granted to the petitioner to file rejoinder list thereafter.
Obliged, Your Lordship.
11.
Your Lordship, item number 11 and number 12 are connected matters, Your Lordship, and both are fixed for rejoinder, Your Honour.
You filed rejoinder?
We'll be filing in the course of the day, Your Lordship.
Okay, record this submits the rejoinder will file the course of the day. List thereafter for hearing.
Right, Your Lordship.
13.
I was directed to take the instruction from my client in this contempt matter, why they have, my lord, filed an affidavit, whereby, my lord, they say that the order of this honorable court has been complied, my lord. It's totally misrepresenting the facts, my lord. Here what happened, I was called before the officer, my lord. They have make an attendance sheet only, my lord. Some discussion was there. They have not disposed my representation. The order of this honorable court to dispose of my representation, my lord, where I stand. But till date, my lord, they have not disposed of my representation.
Is regarding on payment?
Yes,
My
my
lord,
lord.
yes.
How much?
My lord, the petitioner has made certain claims in the writ petition which has not been approved, which is why, my lord, in the original case, my lord, lordship has given us a 1 month time to dispose of the representation of the petitioner, which we did not dispose of, my lord. So the contempt was filed. And, my lord, we have made an offer that we can sit together and have a meeting. Otherwise, my lord, this could have been done in the behind also. We do not require their presence.
They cannot
So
do it
now,
behind,
my
my
lord,
lord.
the decision, the direction of this court was to dispose of the representation. We are saying we have, so it may not be exactly as per the satisfaction, my lord. So we have document proof has been enclosed as Annexure A, my lord.
This minutes, my lord,
He may have any
this
grievance with the
minutes
decision, my lord.
has been taken, my lord, behind my back. I was not aware of that, my lord.
They are signatory to the meeting, my lord.
My lord, this
It
is
can't be
the
behind the back.
Did you go and meet them?
Yes.
Yes, we have
They are
gone and met
present.
them, my lord. My representation still stand, my lord.
Satya Jalan, your signatures here, 10-5.
Yes.
My lord,
I'm not disagreeing with that, my lord.
Where is any
Please let me
document to
complete.
substantiate that it has not been disposed of?
Let her finish, my lord, then I will argue, my lord.
He is
My
present,
case,
my lord.
my case, she is representing, my lord.
The representation has been
No,
disposed
you read
of.
this minutes.
No, this minutes was never taken. That is what, my lord. This is in an additional page.
How are you going to do that?
My lord.
See, Mr. Day,
My lord.
a contempt is whether there's a clear and willful violation of the orders of the court.
My lord, I
Correct?
totally agree.
Now, if you cannot make out a case has been willful violation,
My lord.
and then there's no contempt.
My
You
lord.
understand? Now, from what they've produced,
No.
now they said that Mr. Satya Jalan, that's you,
Yes.
has agreed to a forced proposal.
No.
Director, also, as soon as there's any outcome of matter, copy shall be communicated through his communication.
No, my lord.
Hence, while concluding the meeting, the director so-and-so requested Sri Satya Jalan not to press legal proceedings since corporation making every endeavor to settle the matter at the earliest.
No, that this manual.
How would you say no, yes?
My lord, kindly let me submit, my lord. My lord,
I'll
what
let
was
you
the-
submit, but you talk about contempt. I'm not going to the facts.
No, I'm also not going into
Yes.
the facts, my lord. Only thing is this: what was the order of this honorable court, my lord? The order of this honorable court was to dispose of my representation, my lord. Disposal has to be done, my lord, by them. No disposal was done, my lord. I was called. They have discussed few things, but this minute was drawn, my lord, behind my back. Because in this minutes, otherwise, my lord, just let me complete, my lord.
How, Mr. Day, you put yourself to put. See, the thing is that now, how can you say there's drawing your signatures here?
This is the only page which was given to me. That was not given to me the first page. Or let them pass in speaking order, my lord. What stopped them to pass in speaking order?
Action contempt, okay, fine. The one affidavit has been filed enclosing the minutes of a meeting held on 10/5/2024, wherein the signature of the proprietor of the petitioner is also present. Mr. S. Day has refuted the minutes recorded therein and submits that the same was done, refuses to submit it and submits that the representation of the director's court has never been disposed of. Stop. MS R. Colney on behalf of the respondent submitted that the enclosed minutes are a true reproduction of what had transpired, and that the respondent corporations endeavoring to settle the matter at the earliest. Stop. Next part. In contempt jurisdiction, what the courts discern is whether there is any willful violation of the orders of this court. Stop. From the affidavit file or from the submissions made, no discernible violation has been made out at this stage. Only contempt stands closed, but it's a liberty to take other steps. Yes.
Thank you for your lordship.
14.
May it please your lordship. Lordship, in this matter, we have filed an application for striking out the names of respondent 1, 2, and 4,
Where is the
lordship.
petition? 1, why? 1, 4, and?
1, 2, and 4, lordship.
Yes, Mr. Pandya, objection.
Lordship, yes, in my humble opinion, Lordship, this will further delay the matter, Lordship.
You strike them off?
Yes, Lordship. If we strike them off, Lordship, what might happen is that the respondent number 678, that is the bank, to process the pension and release area, they might need the signature or sanction of the respondent number 1, 2, and 4, Lordship. At this stage, if we strike them off, Lordship, this might further delay.
Miss case number 7024. This is an application for striking of response 1, 2, and 4 from the array of party respondents in the connected WPC number 30/2024. Stop. You are appealing for whom? For the State Bank?
Yes.
Are you releasing the pension?
Lordship, on the last occasion we have filed that they have not submitted the life certificate.
Lordship, I have submitted that on 2 occasions, Lordship.
What was the order passed last?
16.5.
16.5.
16.5. Where's Dr. Mozika?
Lordship is on legs.
We'll take it after some time. Yes. Any instructions?
Lordship, we are awaiting
Will
instruction.
you strike off the parties? Let them come.
Hello,
Item 15.
Yes.
Well, it's in item 15. The state has filed the affidavit as directed by this honorable court. 15 minutes.
Yes.
I'll need some time to file a rejoinder. A very detailed,
When
voluminous
filed?
affidavit they filed. This was filed on the 24/5 minutes.
Okay. After on behalf of the state has been filed 24/5/2024. Mr. K. Paul, stop. Mr. K. Say counsel, please allow some time to examine the same. This up to 2 weeks. Yes.
Right. Well, it's interim orders may continue.
Interim orders will continue the next week.
Obliged.
16.
Please, Lordship, I'll be filing my affidavit service during the course of the day, Your Lordship, because the private respondent number 3 and 4, they have received on 27 March 2024 that the item has been delivered. But due to some difficulty, I could not file the affidavit. I'll be filing today during the course of the day, my Lord.
What about state?
The state actually, on the last occasion, one advocate has appeared actually. It's not required.
Lordship, am I audible?
Yes. Yes.
Lordship, I'm appearing on behalf of the state, and we will first see the affidavit filed by the municipal board because that is the respondent in question.
This is
We have been dispersing the salaries.
Municipal board. Or
yes,
the state has been dispersing the salaries of the teachers.
Mr. Pisa Praise was allowed 1 week's time to file after indicating service on response number 2 and 3.
Yes, 3 and 4. 3 and 4.
Yes.
Most blessed, Lordship.
17.
Right, my lord.
Lordship, in this matter, I am appearing for respondent number 3. Lordship, I pray for 3 weeks of time to file affidavit.
P. Agarwal is the same P. Agarwal who was here just now. Who are you appearing for? What's your name?
For UGC, Your Lordship.
Huh?
For UGC.
Is she there in the Vakalat? Yes, Mr. Datta.
I have no objection.
Objection to what?
For their filing of rejoinder.
I'm also praying for some time, Your Lordship, on behalf
2 weeks
of
further time
respondent.
allowed to respond to file affidavit. This is thereafter and so on. So.
18.
Please, Your Lordship. Your Lordship, I seek your indulgence, my Lord. Kindly grant me some time, my Lord, to file the affidavit.
How much time?
2 weeks,
further time. None appears as petitioner. 2 weeks further time granted to the response to file affidavit.
Much obliged.
19.
Your Lordship, this matter can be disposed of as the election is going to be conducted.
Regarding?
Regarding VC. VC.
Village Employment Council.
What happened?
Lordship, I have filed one case for Impleadment. I am the present president of the...
You are Mr.
Chandra Mohan Das.
Yes.
Can be disposed
With
of?
instructions.
I have.
You file affidavit.
I filed an affidavit. Para 8.
When you holding elections, you said? Yes. You are for your present president?
Yes, Your Lordship.
Impleadment. So you have no objection to
No objection.
impleadment? Yes, the Assembly's case 57/2024. This is an application. This application for impleadment of one Sri Chandro Mohandas, who is stated to be the present president of the Sobri Bari VEC and the Celcelas in RD block. Is not objected to by the land council for the petitioner. So accordingly, Ms. Sri Chandra Mohandas is added as respondent number
5. It will be.
Number 5. Correct. Registry to make necessary correction in the main cause title. In the main case, first right in view order passed Ms. So and so is added as respondent number 5. Stop.
Lordship, I may be allowed to file my affidavit.
No affidavit allowed. Finish. This matter is over. Mr. R.H. Alice, please, who's appearing newly impleaded, respondent number 5, please allowed to file affidavit. Whatever on submission of the affidavit, on proof of the affidavit filed by the state respondents, that the VEC election will be conducted as per the regulations of the MG and RES. This matter is not survived for consideration. So the statement affidavit at paragraph 8 of the filed by the state is reproduced here and below. So,
Lordship, in this petition, they have bring some incorrect information regarding.
doesn't matter. You can file a fresh petition if you also agree. So, accordingly, this petition is disposed of. Direction that the respondent conduct election within 2 months from today. So, the newly impleaded respondent has liberty to institute any fresh proceeding on any proceeding of fresh cause of action arising. This matter stands disposed of.
Much obliged.
Item 20.
May it please Your Lordship. Your Lordship, we have not yet filed an affidavit in this
Yes.
case because we've received some additional information on the 23rd of May. So we may be allowed another 2 weeks' time to
But
file.
Mr. Moment says the covered case.
Covered
It's becoming uncovered now.
Trying to uncover it, Your Lordship. No, because there are some more things, Your Lordship. The department
Let
has...
them file affidavit then. Yes, MS T. Yangi, AAG, so. Please allow for the 2 weeks' time to file affidavit. Just thereafter, and so yes.
Item 21.
You file affidavit, Mr. Devnath.
Your Lordship, my affidavit is ready, but I have to file it sometime.
Today?
Today, not possible.
Tomorrow?
After tomorrow.
What about state? This is the these cultivators have been they're suffering irreparably. I mean, the cultivations go on because of road construction. These are the matters should that it deals with livelihood. Mr. Devnath, on behalf of respondent number
1 and 2.
1 and 2 and MSZ already on behalf of 3 to 11. Pray for allowed for the 1 week's time to file affidavit.
Right, my lord.
Item 22.
Lordship, I'm praying for some time on behalf of Ms. Ailingwa, Your Lordship, to file the affidavit in opposition.
Where's MS Ailingwa?
She has some personal difficulty, Your Lordship.
Maybe.
Urgency is there?
Not urgency, but...
Yes, 2 weeks' time is prayed. Granted to respond to affidavit.
Obliged, Your Lordship.
23.
Go back.
But I'm praying for some time, my lord.
Yes. 2 weeks. Time is prayed loud.
Lordship, I have a prayer, Lordship. Item number 24, Lordship, I may be allowed to amend the cost title, Lordship. What has happened is that...
Let it be called out first.
24.
Excuse me. Yes.
Lordship, what happened was the name of the petitioner is Sri Ram Saini, Lordship. The Sri was
Sri Ram?
Saini, but it was misconstrued as Sri as honorific, Lordship, is instead of the part of the name, Lordship. That was typographical error, Lordship. I may be allowed to amend the cost title, Lordship, with effect to that.
Okay. Mr. Pandey submits that due to inadvertence, the name of the writ petitioner instead of reading as SHREE or IRI?
SHREE, Lordship.
SHREE Ram Saini. The same has been shown as Ram. He prays for and is allowed to correct the same for a period of 1 week. Yes. So,
hello, Lordship.
You know, there's a lawyer in this court also faces the same problem. He's a senior lawyer. You know that, no? Mr. S.P. Mahanta, his name is Sri Prakash Mahanta. So they thought, so when it came, someone said, who's this Prakash Mahanta?
Yes.
25.
I love life.
Who's the pairing for number 3? 3 and 4. Who is whom, Mr. Shilla?
Lordship, there's a development in this matter, Lordship. So far as the impugn order is concerned, Lordship, that has been recalled by the District Council. We'll be placing that, Lordship.
They have communicated to us, Lord, so we are satisfied with that.
Is there a growing boundary?
It's boundary issue, Lordship.
We'll look into the matter again.
So we'll close the petition now?
Yes, yes, ma'am.
When the matter is taken up today, Mr. M. Nongpur, on behalf of respondents 1 and 2, has produced a communication dated 15 May 2024 addressed to Wahesh-nong Yalong and Wahesh-nong Pasi, whereby the impugn order has been dated 26 Feb.
26 Feb.
Yes, ma'am.
Has been recalled, and that the matter would be relooked at afresh. In view of this development, Mr. J. Shilla and the council petitioners praise that this matter may be closed at this stage. Accordingly, on the submissions made and as per the communication dated, that was
15 May.
15, so the matter stands closed and disposed of.
Second call, item 14.
Yes, Dr. Mozika, that bank matter, you supposed to take instruction to help this poor lady, retired.
Awesome.
That proof of life. Petitioner said twice they have gone showing proof of life, but a pension has not been released.
22 and 23, subsequent years, Lordship. Petitioner has gone to the bank.
Where is that lady advocate who was here just now? I think they're not properly instructed. You have to wait for the matter. No, the way the court's going on is, you guys know Shula, it's not like what it was before. Before there's some discipline. Now there's no discipline between this. You don't know whether the matter is taken up, no, you don't wait for the matter also. You have to draw sumo to contempt against some people then. If the matter is going to be called out, you wait in the court. Yes. Yes, Mr. Dr. Mozika.
My lord, what department say, Assam Rifles says, my lord, now this is, as far as they are concerned, their parties, they don't have any role now.
No, he is supposed to, Assam Rifles is supposed to contact respondent number 3. That's why to help the petitioner. Or section number 3. Number 3 is the bank.
Number 3 is pay and accounts officer, Lordship.
Pay and accounts officer.
Yes.
6, 7, 8 are the banks, Lordship.
Are you leasing the money or not? Okay. Dr. Mozia, see, we're not going to strike out parties right now because they have to know what's the amount of the bank.
Yes, Lordship. They still need to be in the loop,
Three
Lordship.
parties now. Assam Rifles is functus officio kind of thing, will it?
But then
Pay and
respondent
accounts
number 3
officer
is a
and
pay and
bank.
accounts officer who's the effective respondent.
Right.
He has to inform the bank so the money can be released to the writ petitioner.
I was seeking instance how it works, my lord, because I'm not very clear myself.
First thing in this case, this is an application for striking off
The names of 1, 2, and 4.
1, 2, and 4 Maria parties on the ground that no relief sought against them. Stop. If the matter concerns the non-release of the terminal benefits to the writ petitioner in spite of proof of life, what's it called?
Life certificate.
Life certificate, Lordship.
Being furnished in the year 22 and 23. Stop. Your bank, what's your name? No, your name, counsel. Yes, next MS also appearing for the bank respondent number 6 and submits that the non-release is due to the fact that the amounts have not been communicated by the respondent number 3. Stop. Before this case taken up for consideration, before any expert of this case, it is directed that Mr. Dr. Mozika obtain concrete instructions from respondent number 3 as to the status of the pension of the writ petitioner, pension payment of writ petitioner. A list on after 1 week, and the main case list together so and so. Just
Okay, for
obtain
2 weeks
because-
time. 2 weeks time.
2 weeks time. Because otherwise they're suffering. Yes.
Hello, Lordship.
Hearing item 26.
Where's Mr. Siddiqui?
Yes, I'm here, Richard.
We dispose of the matter today.
Your Lordship, let it be next day, Your Lordship.
No, see, because the court has said examine the matter. So court has taken the pain to examine the matter now. The only point that can be looked at is issue number 17. Whether issue 17 was what? Mr. Karshin has read it out. The plaintiff.
Whether the defendant is liable to be evicted from the suit property.
Yes. Whether defendant is liable to be evicted from suit property. There is no discussion on that, only on the findings. The findings are concurrent findings. So this court will not touch on concurrent findings. The thing that remains is that, so that you be prepared for a hearing, is that now you are second generation. Is not a question of your mother and her mother staying in the same house any longer. And the decrees all been passed. You made a declaration which was, that is wrong on your part. Now the same situation now, the law as it stands is that the youngest daughter is a custodian. So she'll be vested with ancestral property. It's only that one issue. And even, I don't think substantial question of law at all arises. So if there's no substantial question, we will not frame it and we'll dispose it off. That in view of the appeal and substantial question of law is that, and also second generation now, so that the inter-party rights are totally different from the substantial question of law as made out that can a co-sister, a sister, so that youngest be evicted from the property of her mother. That's not the situation any longer here. You understand?
Yes, sir.
I thought we'd close the matter today. But
Let it be next week,
concurrent findings, very difficult. I've gone through both the the trial court order and the appellate court order. And on appeal, only two issues were taken into consideration. Not even this issue, 17. But just since it's a point of interest, so we're taking it up. Only 2 points is whether it is abated. It can't abate because of Order 22. If a matter has been heard while the plaintiff is alive, and between the hearing and the pronouncement of judgment, if that person dies, then as per Order 22, I think Rule 6, if I'm not mistaken, then it's taken as if when the decree or judgments pass, it's like the person's alive. So on that ground, your appeal will not succeed. Abatement. The only point of interest was that the eviction aspect, that issue number 17. And the appeal, other ground of appeal which they have taken second appeal, first appeal rather.
Page 34, madam.
Another interesting thing is that now knowing that the original younger daughter had died, that is Ultima, correct? When you file your appeal, you didn't make them a party also. That's correct. When you file a first appeal before the judge, that's correct. They didn't make a party. You filed for impleadment yourself.
Malud.
In the appeal, you filed for impleadment, correct? You were not impleaded as a party in the appeal. You filed for impleadment, then you impleaded.
Yeah, Malud.
See, the sisters, they have a right to occupy a portion of property if they don't have anywhere else to go, as you see, like Upasanas. But now comes second generation. You prepare, I will close it. When the matter is taken up, Mr. D. Hinyata expresses his difficulty in concluding hearing today, in conducting hearing, sorry, unless it's a matter for 1 week. And honestly, he made me read the file. Yes. Next matter.
27.
Please, Lordship. Lordship, by order dated 30/11/2023, your Lordship has passed an order stating that allowing GHDC to take steps to take instruction to how will they elevate the suffering of the petitioner. So since that point of time, my Lord, since November 2023 till date, the instruction is not forthcoming. So my Lord, I pray that this matter may proceed for hearing, my Lord, because enough opportunity has been given to District Council. And prior to this also, they have stated before this Honorable Court that that due to non-availability of
Have
funds.
you seen the money now?
No, madam.
No money from the state?
We have not received anything, madam. In fact, there is a contempt also pending.
That is for salary, my Lord.
That's for salary, this is for pension, my Lord. In that one, my Lord, we have filed an affidavit stating that 72 crore is outstanding from the state government, my Lord. That is excluding the receipts from transport
I
department.
want to know one thing. How is Khasi Hills managing the finances so well and Yanta Hills?
My instruction that recently state has released their share, my Lord.
No. All along, you don't have these applications coming from the pensioners, anything from KHDC?
Because one thing is there, my Lord, that monthly bill, monthly bill is around 8 crore rupees.
So far, pension is concerned.
Pension and salary.
Pension is concerned around 50 lakhs, my Lord.
How much?
Around 50 lakhs.
50 lakhs?
Yes, for all the pensioners. But we are here only 62 of us before this Honorable Court.
Whatever it is, if it goes, it has to be across the board.
Yes,
it can't
yes, my
be.
Lord. Yes, my Lord.
Yes.
My Lord, and in fact, in our petition in Annexure 6, My Lord, we have mentioned the fact that besides the share that the District Council is expected to receive from the state government, they are generating their own revenue, my Lord. Around 7 in 2019-20, the share, the revenue they generated is around 7 crores 71 lakhs. In 2020-21 is around 8 crores 12 lakhs.
From which sources?
From their own sources, my Lord. And that apart, they have a fixed deposit as per this this RTI, my Lord. They have a fixed deposit of 12 crores and they are generating an interest of 3 crores rupees.
12 crores can generate interest of 3 crores?
That's what they have said, my Lord. Around 3 crores. This is as per the RTI they have furnished to us.
Something wrong. How can you, on 12 crores, how can you generate 3 crores?
My Lord, that is what...
If that is there, I'll put my money with FDOs.
My Lord, yes. But that is the RTI that they have given to us, my Lord.
What is that?
So, my Lord, basically what I'm saying is that maybe one aspect of it is that they have not received the share from the District Council.
One thing, Mr. Shilla, we can't pass orders which are impossible to comply with.
My Lord, what we are saying is, my Lord, I understand, my Lord, but
we can pass orders, yes. But the thing is that what's the point going to contempt, even go to the Supreme Court also, they might have to face jail term and they can't cough up the money. What are you going to do?
My Lord, in this, as per the instruction of my client, my Lord, they are facing great difficulty, my Lord. It's affecting the livelihood.
Yes,
now for 12
pensioners especially.
Yes, for 12 months, my Lord, they have not received their monthly pension. And we are not asking for gratuity or anything. We are just asking for the basic monthly pension.
No, we understand. That is why last line is like, what steps you're taking?
My Lord, and that for that, since November, no instructions giving, my Lord. They have not come up with instructions.
When we last paid pension?
Till May, my Lord.
Till May 2023, my Lord.
Now, 1 year.
Yes, my Lord, for 12 months now. And
what assets does it have, GGDC?
That's what they have lots of lands.
You can attach them.
Yes,
District Council's lands.
Yes, they have lands, forest lands, my Lord, all under their jurisdiction.
The jurisdiction, but whether they are the owner of the land.
They are the owner. But we are compelled to make this submission, my Lord. All this while we have...
I understand. You have to do something.
Yes,
you have to pay them. At least some bridge amount, like maybe for 4 months, or you have
my
to...
Lord, it appears that the pension amount is not that significant. My Lord. You can explore the possibility. At least...
You have to pay them. They can't... They will die then.
Yes, my Lord. And now our monthly pension is just half of the salary that we used to receive. And even then also, my Lord, we are not getting it. And this is basically the only source of livelihood for us, my Lord, at this stage.
Constitutional authority can never say it has no money. That means if constitutional authority says it has no money, it's a breakdown of that piece of constitutional machinery. And that's unconstitutional. So you want to make those observations also, because you can see that you have to make some arrangements. Even if
the state could come up with something.
Even if we're not waiting for the state, even if it means, like underwriting the whatever loan you get from some financial institution. Pakistan's running out of money, but they kept on begging from IMF.
No, in fact,
same thing. In fact, like a situation like
there was a situation in Andhra Pradesh, my Lord, during COVID time. They deferred payment of pension on the ground of financial difficulties. So a writ was filed before Andhra Pradesh High Court, and that was the observation, my Lord, that financial constraint was not a ground to deny pension. And the appeal was made by the government before the Supreme Court, and Supreme Court upheld the order.
You cannot, yes. And counter also that impossible orders, if they can't, that even they go to Supreme Court, they can't do anything. It happened with Uttar Pradesh, Allahabad. So some order was passed, and the government said it's impossible to comply. We don't. Is that financial something else?
And in other cases, my Lord, they are asking for interest also, for delay of payment of pension fee. For us,
Contempt will send the CM to jail, Dr. Mozika, for 2-3 days.
Only the secretary is a party in contempt also.
Secretary. Will send secretary to jail for 2-3 days.
Totally.
Something must be done, my Lord, because I understand if they will have asked time for 1 month, 2 months, but now it has been...
can intervene, at least help the district council in getting some kind of...
That is the it's...
Since they are party, the state has a constitutional mandate to help the district council.
Lordship, my friend is
out of their.
me
No,
for
it's
this
not a question of shooting.
My lord, this is very unfortunate that the learned senior is making this submission, my lord. The pensioners who are, their livelihood is affected, now he's making that kind of submission that we are shooting through the shoulder. Is this appropriate, my lord? We are demanding for our rights and he's saying we are shooting through someone's shoulder. Now will be in the street in a few months, my lord. They expected us not to come before this honorable
but
court.
you have to make some arrangements. How much is due from the state from your royalty?
72 crore.
As on date?
As on April. As far as pension is concerned, my lord, I'll have instruction, my lord, if they can release at least some installment of that one. But salary will be beyond our capacity, my lord, until unless we get something from state.
Because you can't have the same kind of excuse that, waiting for...
That's true, my lord. But there are no other sources of revenue. Other sources of revenue, the total generation is 6 crore, 7 crore. My lord. There are other administrative expenses also.
Yes. You take down this matter concerning the non-release of the pension amounts, monthly pension amounts to the petitioners herein has received a serious consideration by this court. Stop. Inasmuch as per the submissions of the councils, the pensioners have not been given their pensions for nearly 12 months now. Next paragraph. Financial constraints has been the excuse and reason that has been given consistently by the respondent number 124 for non-release of the pension. Stop. Pension, funds of pension stop. It is also submitted that these financial constraints have been caused by the non-release of the share of royalties and other dues as permissible by the state government. And as reported by Dr. N. Mozika, the outstanding dues are now over 74 crores.
72.51.
72.5 crores as on
April 24.
April 2024. Stop. Next paragraph. Mr. Andy, should I learn AAG for the state government, for the state respondents? Has not received the instructions or given any reasons as far as state respondents are concerned for the state of affairs that is prevailing within the GHEDC. Stop. Next para pension is not a bounty, but a right that is accrued by persons who have given the best years of their life in the service of an institution or establishment and are dependent on it for their survival. Stop. The deprivation, therefore, of nearly 12 nearly 12 months of pension to the petitioners is shocking, to say the least. This court, in other petitions which had been preferred by employees of the JDC, had also issued directions that the state examine and consider the condition of finances of state, to examine and assist or to raise amounts as due to the district councils. And though this court cannot enrich jurisdiction, or they cannot issue directions to command or direct the state respondents to take up this matter and to raise the funds. It appears that the observations made here and above are necessary to make them aware and alive to the serious situation. Stop. In this view of the matter, therefore, as the respondents 1 to 4 have expressed the inability in the current situation to alleviate the sufferings of the pensioners, it is observed and directed that the state respondents take up the matter with the respondent 1 and 4, take up the matter of release of share of funds stroke royalty, if not fully, even partially, to enable sponsor 1 and 4 to disburse the same as necessary. Stop. Mr. Andy Shulai, then EAG. You haven't filed affidavit here?
No. We'll have instruction, Your Lordship.
Is also permitted to obtain specific instructions.
Lordship.
And to file affidavit if necessary before the next date. Yes. List on?
After 3 weeks.
2 weeks, madam. 2 weeks, madam.
List after 2 weeks. Okay. You can't do that.
I'll have instruction, Your Lordship.
At least you give some bridge money to them.
29. 29.
Yes.
Well, in this pertains to election of the managing committee of the school, my lord. On last occasion, we placed the rules, my lord, which say that the president and secretary are to be nominated by the government. They are not to be elected, my lord. Now, state on the last occasion, if I remember,
It's not correct, they say.
They are saying it's not correct. Now, at least states would disclose which rule says that there has to be election, my lord.
We have received a letter from the office of the director.
What does it say?
It says, of course, it does not refer to the rule, but it says.
Does not refer to the?
But if I am allowed to.
Yes.
The rule which is quoted in the writ petition, that definitely does not apply. That is for sure.
Definitely does not apply.
Because the rule which is referred in the writ petition, they are referring to Assam Education Department rules and orders.
Yes.
So that does not apply.
But that's been followed.
No, no. If it is followed, my lord, it has to be, my lord, the Assam aided higher secondary, high and middle school management rules.
Where's that? Sure.
So that, of course, specific clarification has to be there. That is not there in the letter.
May I submit, Your Lordship? Your Lordship, the Governor of Meghalaya has, in exercise of power conferred under Section 38 of the Right of Children to Free and Education Act 2009, has framed rules called the Meghalaya's Right of Children to Free and Education Rules 2019. And as per Rules 11, Your Lordship.
Give the rules, show to the, give a copy to the court.
That rule will apply if it is an excessive.
What school is this one? Aided school?
Aided school.
Your sanctioned teachers?
The sanctioned teacher.
Of course, this letter, there is nothing specific, my lord, which rule applies. My lord, if kindly is kind enough to grant me some more time so that we get a very specific answer as far as the management of the school is concerned. Otherwise, my lord, the other rule which I am aware of is, my lord, the amended Assam aided high and higher secondary schools employee rules.
Where's that old book, Education Code, Vicky, the one? That book has all those rules.
My lord, I still have
Education
one,
Code. Where's that book? You have that book with you, Education
my lord,
Code?
it got lost. I still have one.
How will it help the code if it got lost? But that's a book when we were practicing also, you know, that
Yes.
all the Assam Education rules, orders were there.
Yes, my lord.
Not this one. This one also more than not adapted, not implemented. Where is that Assam one?
My lord, of course, that is related to the employees, my lord. And as far as the management is concerned,
1 second.
for management is
Assam,
concerned,
Assam.
it should be the Assam aided higher secondary, high and middle school rules management rules.
Which year? Just let me copy that. Which year about?
These 97 rules are never implemented. This Meghalaya aided higher secondary.
They will not apply to Meghalaya.
No. This Meghalaya rules of frame also.
I have to get a specific answer.
They were not implemented. That's why education is a mess here.
Because the letter says that it is.
Director of the school doesn't know, my lord, what rules are applicable. My lord.
That is, you see what rules of frame also, and they were put up for, you know, for the cabinet and all for, I believe.
For political considerations.
But then because it's so political considerations were there, that's why the education thing is a mess. Because the managing committees become little power centers for schools, for these, I mean the schools. We have to have instead of uniform civil code, you have uniform education code. Okay? Yes. You can't have any Tom, Dick and Harry opening a school, appointing his grandfather as president, appointing his son as teacher. You know, you can't, that's happening in all these schools. Grandfather gets kicked out, he appoints his, another fellow comes, appoints his grandmother's, whatever.
That's what I was thinking, my lord, if clear directions are passed in this case, my lord, and this will resolve all the
But the
problems.
rule which is stated in their petition, that is not.
No, but those rules are followed, you know, and other things. When it suits the government, they follow them. It doesn't suit the thing, then it's not followed.
At least I may be allowed some time for specific, which rule.
Mr. Kivarche though has produced a communication dated 18 April 2024 with regard, submits that appraisers sometime be allowed to apprise his court fully and factually.
Which rules are applicable and which are
applicable
which
in
rules are not
such
applicable?
matters.
Also, my lord, which rules are not applicable? No?
That's the applicability.
I can understand difficulty. It's very difficult.
34.
Just after 3 weeks, yes.
34.
Where's the petitioner?
I think.
Lordship,
You ready with the matter?
Lordship, we have taken time for seeking instructions. Lordship, the management committee, they are holding a meeting. And Lordship, I believe we will be going ahead with the hearing of the matter or to be disposed on merits.
Merits, no merits. Now they've already shown that, you know, how the amounts for the delays, when is the due and the delay, and that's how they've computed the entire thing.
Lordship, there is another aspect to it also, Lordship, that they have waited themselves for almost 20 years and then they served us this notice. However, in the meantime, prior to serving this notice, they had also served us a notice for a period which is later than the period under reference as of now.
Well, you come physically and do it then.
Lordship.
After get your you prepare a management committee, says the reason that the amounts were due. So the only point is whether delay will enable you to get any reduction. But you already
Lordship.
paid.
They have already paid. They have already
Lordship, paid as in they got deducted from our account.
1 week, yes. We'll close it. Enough of. You tell your management committee the matter will be done, yes.
Lordship, it may come up after 2 weeks.
And
we'll be holding a meeting.
the you know, hope of any relief is very bleak. That's all.
Lordship.
Yes. This is a very
Lordship.
draconian law.
Lordship.
You can't help it. Not
Lordship.
draconian, social beneficial law. Yes.
35.
Yes.
But 35 can come up along with 27, my lord. This
This
is
is again, my lord.
Yes.
State has filed the reply, my lord. State has filed the reply again relating to issue of payment of
Mr. Alvin, do
state's
something.
share.
Give them some bridge amount. If some
We
amount
have been, Your Lordship, in fact, we have been making the payment time to time. Now,
no,
the
otherwise you
only
do one
issue,
thing,
my
just,
lord, is
payments are released selectively to some district council, my lord, not to JNTIs.
no, we have been making the payment. Now, my friend can make
Who's the
all
CM
kind of
now?
allegations
Who's
selective.
the CM of this council?
They can go under paragraph 9. They can go paragraph 9. They can complain to the governor. My lord, paragraph 9 provides there is a mechanism under paragraph 9 to go to the governor if they are aggrieved with the stand of the state government. Paragraph 9, your lordship,
That is only with regard to
paragraph
percentage.
9.
See, percentage, even percentage also.
We have been.
Now it's 25%, correct?
Yes,
before
Lord.
before it was 40% or something. Now 35%.
Yes, right now, my lord, it is 25%, if I'm not wrong. In respect of, yes, my lord. And time to time, we have been making the payment. Now, what the problem, my lord, is, root cause is, my lord, that they have got the employees, your lordship has got the experience, which they have employed without any process of law.
Only
And
thing,
the
one
number
thing
of employees
just,
they have.
today, Mr. General, on regard to the pensioners, we already passed some orders, at least, like, you know, that some,
Yes, I have seen, my lord. I have heard,
some small amount be given.
27.
Are you 12 months will die?
Yes, my lord. I will convey, my lord. I will convey. So that, but this problem will keep coming, my lord. Keep recurring. So far as pensioners are concerned, we will try to ameliorate their situation.
And amount
but
very
unless
small also.
And
amount
yes,
very
amount
small.
is small also.
20 lakhs for the entire year.
Yes, my lord. Yes, my lord.
One
So
more.
that can be taken care of. But the only thing is, my lord, if your lordship will pass the order that the amount if released by state government should go to the pensioner only, not for any other purpose. What is going to happen, my lord, if the amount is released to
Yes, yes, that.
GHDC? That
No,
amount
one
can
thing,
be.
we'll discuss together
Then-
on the, with
First
item
let's
number
state
27.
release. We'll see.
Then we'll see this.
Because now,
Let them release first,
Yes.
my lord.
Lord,
Then
if
can
I
write
may
it.
After 2 weeks.
yes,
After
if I
2
may
weeks,
just
my
highlight
lord.
the
Yeah, along with item 27.
if I may highlight the ground realities, my lord, the because of the non-payment of salary to these people, my lord, the work is affected. Even the judicial work is affected, my lord. Now process
For
server.
judicial work, we think the government should take it up that we should separate head for judiciary. That won't be affected.
Because now
That will be
process
like
server,
the taking over primary schools and taking over by government of judiciary.
because now
also.
process server are not serving, my lord.
We understand that. Yes. Right then.